If anyone is joining late, please help them out with the page number or topic name, medico-legal aspects of medical practice. So even in medical practice, there is an increase in medical legal cases. Okay. And because of this reason, physicians should also know how their how the medical law of the land where they are practicing affects the medical scenario. Okay. So they should know their rights as well. Okay. They should know how to keep up a doctor-patient relationship. Okay. So doctor-patient relationship or doctor-doctor relationship, doctor-state relationship. Okay. These all comes under the duties of the doctor. They should be aware of it. Practitioners should be aware of this. So some medical legal issues are quack, a person who does not have a knowledge of a particular system of medicine, but still practices that. He's called a quack, or he or she is called a quack. Okay, this person is guilty of negligence per se, and there is no further proof required. Okay, like a homeopathic doctor who is prescribing allopathic medications. Okay, an Ayurvedic doctor who is prescribing allopathic medications. So these comes under quacks. Okay, so they are not supposed to. What system of medicine they are trained in, they should only prescribe those medications. Okay, they are not supposed to jump the systems of medicine. Next is informed consent. There exists a duty to obtain prior consent. Okay, especially when it comes to living patients, even for diagnosis, treatment, organ transplant, research purposes. Okay, disclosure of medical records, teaching, medical legal purposes. For all these things, informed consent is required. Coverage of doctors and hospitals under Consumer Protection Act. Even medical profession and the healthcare services, they come under service sector. Okay, so they are also covered under Consumer Protection Act. All the patients here, even if you're giving free medications, free treatment, still the patients are considered as consumers. Okay, even if the medication or the treatment is given free of cost, patients are still considered as the consumers. Claim of damages. The claim for damages based on the claim for damage is based on the principle that if a person has committed certain civil wrong, he or she must pay the compensation by the way of damages to the person who is wrong. Here, the hospital usually gives the claims. Okay, the claims are paid by the hospital, and hospital is also insured. Certain insurance companies, they also insure the hospital against any claims. Doctors also have such insurance to cover them against any claims. So other important points to remember: death of a patient while the patient is undergoing some treatment does not necessarily mean that it's a medical negligence. Okay. If there is an error of judgment or failure to cure a disease, that also does not mean it's a medical negligence. Engaging with a specialist, okay, when the specialist is available, is obligatory. Morally, it is correct. Okay, if a specialist is available, you have to take the specialist opinion. Okay, the doctor has to take a specialist opinion. In case of critical conditions, if the patient is operated under critical conditions, doctor cannot be held guilty or of negligence. Okay, in critical conditions, you can't wait for consent to come, or you can't wait for some law enforcement people to arrive. You have to treat the patient first, save the life first. Okay, in such cases, medical negligence cannot be applied. Then incomplete medical history. If the patient is giving incomplete medical history, it cannot give. It can you cannot hold the doctor responsible for it. Okay, if the medical history was given wrong, if the patient himself or herself lied to the to the doctor, or hid purposefully, they had hidden some facts from the doctors. Okay, in such cases, then liability of hospital is liable for any wrong claiming on the part of the consultants. Doctors don't pay the claims directly. It is the responsibility of the hospital to pay for the claims charged by the patients. So far, is it clear to all? Next, exceptions to informed consent. There are certain exceptions that may not apply to informed consent. So, in case of any emergency situation, you can't wait for the informed consent. While working in situations of public interest, like during floods, cyclones, earthquakes, etc., treating patients in places like mental asylums, orphanages, informed consent cannot apply. Working under court's order in case of smuggling or operations done detecting narcotics, or gold is kept inside the body orifices. Okay, in such cases, these are some smuggling issues. Okay, gold or drugs are kept inside the anus, or they swallow and they are screened through the airport security checks. Okay, in such cases, so even without consent, the court order, uh, you can check the patient. So these are the exceptions of informed consent. Certain laws that are relevant to doctors and nurses. Criminal law is applicable to all individuals, and doctors are also not an exception to it. Doctor patient relationship has also deteriorated in the past few decades, and complaints against doctors and even the hospitals have increased a lot. Unfortunately, in many cases, a doctor treating with good faith also becomes a victim of medical negligence complaints just due to mere documentation error. Therefore, doctors must be aware of the criminal laws and their legal implication to make themselves immune from such situations. And even the doctor-patient relationships these days are deteriorating. Okay, patients harassing the doctors, abusing the doctors. Okay, such news are very rampant. Physically assaulting the doctors. Okay, in an ER ward or in the operation ward. Okay, act of good faith also does not help the doctors a lot. Okay, any act done by a doctor is considered to be done in good faith. That also is not able to cover certain charges. And awareness should be there because of such situations, such turbulent situations that we are facing. Awareness should be there from the patient's side, and as also as well as on the doctor side. And also the law enforcing agencies should have the same awareness. Coming to certain sections, section 304 or 304A, death due to medical negligence. So you have to be little discreet in applying this law because it may cost a lot to a medical professional if the accusations are false. Okay, so most of the time the police authority registers cases of professional negligence and death under section 304. According to this section, the offense is considered non-bailable. That may lead the doctor to huge hardship, mental agony, and professional stigma as well. So you have to be you have to check all the areas properly before applying for this accusation. The police should register the cases of deaths due to medical negligence under section 304 IPCA, in which again the offense is bailable because there is a difference. Section 304 means it is intentional. Okay, the harm was caused knowing that the patient will be it may lead to death. Okay, but 304A, intention was never to cause death, but by mistake, because of bad timing or some mistake, it led to death. Okay, but intention was not to kill. That is section 304A. Okay, that is bailable. Then section 319, 322, grievous hurt. In these sections, uh, these are related to causing grievous hurt such as loss of limb, loss of vision, loss of hearing, or disfigurement. Okay, where section 336, 338 deal with causing grievous hurt by rash or negligent act. Examples include, so this in this section, uh, your action, a doctor's action caused a serious harm or serious injury to the patient that could also lead to loss of certain motor or neural functions. Okay, like leakage of IV fluids from the surrounding tissue. If the IV cannula is not placed properly, okay, that could lead to spasm in the vessels, and the vessels may block, could lead to necrosis of the limbs. Okay, anything bad can happen. Then surgical procedures without any adequate aseptic precautions, that also results in local infection and also subsequent loss of vision, limb, hearing. Aseptic precautions means you are not careful with the infection. Infection control practices were not followed. Okay, that is aseptic. An unqualified doctor performing surgical procedures which results in permanent damage to eyes, limbs, hearing, etc. Only skilled doctors who are confident in their skills are supposed to conduct carry out certain procedures. Okay, underskilled and unqualified doctors doing certain procedures uh, they could be charged with grievous hurt. Knowing that they are unskilled, they still try to do certain procedure. It's intention. Okay, so that could lead to grievous hurt. Then you have section 340, 342, that is wrongful confinement. A patient cannot be detained on the grounds of non-payable no non-payment of hospital charges. This may constitute the offense of wrongful confinement under section 340, 342. Doctors can take advance fee from a patient before starting the treatment, but just because not being able to pay the fees Okay, you can't confine the patient. Okay, you can't force him to stay in the hospital until and unless you can't ask them that they will not leave the hospital premises until they pay the bills. If a police officer is keeping a doctor in detention in case of bailable offenses, the police officer is liable. Okay, in bailable offenses, the doctor should not be detained. So that comes under wrongful confinement. Consent in criminal law. A valid consent must be given voluntarily by an adult who is in a sound mental state. Consent must be given after reasonable understanding and without misrepresentation or hiding of the facts. Thus, consent should be an informed consent, preferably in writing and even in the presence of witnesses. So that is how consent has to be taken. It should be voluntary, it should never be forced. Okay. Minors cannot give consent, neither people who are not who have deteriorating mental health condition, they cannot give consent. Informed consent means you give them the choices of treatment, risk of this treatment, okay, risk associated with certain procedures, everything is mentioned. In case of organ transplantation, the donor may have given consent under certain family pressure, social pressure, or financial pressures. Okay, that has to be rectified. Okay, you are not supposed to take organ donations from anyone who has been pressured into organ donation. Okay, therefore, the consent should be taken only after proper counseling and also in presence of witnesses. And in case of dead donors, if there is no will expressed, okay, the body is the property of the heirs and their consent is required. The law imposes liability on him, criminal liability for wrongful act. Law imposes liability on him who fails to perform duty. Okay, the doctor has a duty to perform that they should not cause any harm. Okay, uh, cause no harm. That is the duty of the doctor. And if a doctor, it has been proven that the doctor has failed to perform this duty, okay, it is a criminal liability. And in medical practice, it does not apply because the medical practice itself, the doctor will never should never have an intention to cause harm to the patient. Okay. Other relevant laws, negligent act. If the doctor fails to take proper care, precaution, and is just indifferent to the consequences of act, okay, whatever I do, I will not, it will not affect me. Okay, that is a behavior of a person who is completely indifferent. I will do whatever. Okay, let them do whatever they want to do. I will do only what I wish. That is an indifferent, okay, behavior. Okay, so if in such behavior, if a doctor is giving some medical treatment, uh, and because of lack of skill also, if they continue to give the medical treatment, that amounts to negligence. Wrongful or special status, some strict liability created by some special statutes like Transplantation of Human Organ Act 1994. So in that is a strict liability act. Okay, you cannot escape that. Like you cannot charge for the organ donation, kidney donation, whatever donation. Okay, it cannot be charged. It there is no remuneration that you get because of organ donation. Then summons. It's a process of the court asking the defendant to appear and answer the allegation preferred by the party who has brought the action. Okay, that is the plaintiff. That is summons. So if the court has summoned you, means somebody has given a case against you and you have to appear in front of the court. So asking you to appear in front of the court, that is called summons. Or you will get a letter that you have been charged by so and so under so and so case. Okay, you have to appear on court on so and so date. Okay, that's a summons letter. Then you have warrant. Warrant means an order issued by the court, magistrate, or even any competent judicial authority. Okay, directing a police officer to make an arrest, seize or search a property, or to perform any other duties that is incidental to administration of justice. Okay, so that is a warrant. With a warrant, with an arrest warrant, only then the police can make an arrest, okay, or make or search a property or do any duties. Okay, to enter a property or premises, you need a court's permission to do that, and that permission is what we call as warrant. Search warrant, arrest warrant, raid warrant, okay, like that. So all these warrants help in the administration of justice. Then a warrant case is related to an offense punishable by death, life imprisonment, and also imprisonment for more than 2 years. For example, if a doctor helps a pregnant woman in an unauthorized abortion, okay, medical termination of pregnancy, or causes death of her child soon after birth, okay. So if the doctor is helping in this crimes, okay, it can lead to life imprisonment as well. Cases other than warrant cases are called summons cases, as I mentioned earlier. When you get a summon means you have to appear in front of the court on so and so date. That is a summons. For example, if the doctor acts negligently by using an infected syringe or by using improperly sterilized instrument, resulting in an infection to an uninfected patient. That's an example. Then you have cognizable offenses. Cognizable offenses are those in which police officer may arrest without warrant. No warrant is required under the Criminal Procedures Code. Without warrant, immediately police officer can arrest. Non-cognizable offenses are which without warrant you can't make an arrest. Police officers cannot make an arrest without warrant. Okay, for example, a doctor knowingly disobeying a quarantine rule is liable to be punished with imprisonment up to 6 months or fine. Then ignorantia juris non excusat, mistake of law, which means like for example, if you are a medical practitioner from abroad, you didn't know about certain medical laws in India and you broke a law. Okay, you didn't have the knowledge of it. That's why you broke a law. Okay, so such cases come under ignorantia non excusat. Okay, which means you are unaware of the existence of certain law by mistake, and it is not excusable just by stating that you are unaware of such law. You cannot evade the punishment. You will have to face the trial. For example, if the doctor carries out any prenatal sex determination in India, sex determination is banned. Okay, so if the doctor is conducting some prenatal sex determination and informs the patient parents about the sex of the child they are carrying, okay, you cannot avoid prosecution just by saying you were unaware of the law. Okay, the doctor will be punishable under such act. Mistake of the fact is the situation where a person commits an unlawful act due to wrong conclusion or understanding, but it was never the intention to cause some bad thing. So in such cases, they will not be held responsible. Okay, that is the mistake of the act, because you came into a conclusion without understanding the situation completely. Okay, so you can't be guilty just to come under certain conclusion. Then you have res judicata. So res judicata, again, this doctrine means things have been decided. Once a person has been punished for some wrongdoing, okay, or a settlement has been done between two parties, then you cannot go to trial for the same case. It cannot be tried again and again between the same party. For example, if the patient has already sued a hospital for any negligent act, okay, damages or malpractice, and the things are subjected to settlement or compensation, okay, and then you cannot again go and charge the doctor again separately for the same negligence. Okay, a doctor gave you a wrong medication, you fought in the court, you won the case, okay, few months after, again you can't fight the same case. Okay, the settlement was done or the claim was given or the punishment was given. Okay, after all that, again you can't try for the same case. That is res judicata. Then res ispa loquitur. So situation is so gross or negligent or so rash. The action was so rash that you don't require any proof. Okay, whatever you have done, it speaks for themselves. Okay, no other proof or documentation is required. For example, giving wrong blood to the wrong patient, okay, or operating on the wrong side of the body or the wrong patient. Okay, that is res ispa loquitur. So in such cases, no further proof is required. Whatever harm you have caused is so evident that no further proof is required. So that is res ispa loquitur. So that's all for medico-legal cases. If you have any queries, you can mention in the chat box.